Welcome to this lecture. Today I will discuss the offences against the public tranquility that comprises from section 189 to 197 of the Bharatiya Nyaya Samhita. Section 189 to 197 of the Bharatiya Nyaya Samhita 2023 constitute the statutory framework governing offences against public tranquility. Addressing unlawful assemblies, rioting, affray, and act prejudicial to the social harmony and national integration. Section 189 defines when an assembly of 5 or more persons become unlawful assembly based on its common object. Section 190 embodies the doctrine of constructive liability, making every member of such an assembly guilty of an offence committed in prosecution of the common object. Section 189 of the Bharatiya Nyaya Samhita defines rioting as the use of force or violence by any member of an unlawful assembly. Section 192 criminalizes wantonly giving provocation with the intent or knowledge of the likelihood of causing rioting, thereby covering incitements that may not culminate in actual violence. Section 193 imposes liability on the owner or occupier of land where an unlawful assembly or riot occurs unless they can prove lack of knowledge or inability to prevent such gathering. Section 194 of the Bharatiya Nyaya Samhita dealing with affray penalizes situations where two or more persons fight in a public place, causing alarm to the public. Unlike unlawful assembly or rioting, affray requires neither a common object nor prior consent. The offence arises from mutual combat disturbing public peace. Section 195 punishes assault or obstruction of public servant engaged in a suppressing riot or dispersing unlawful assemblies. Section 196 of the Bharatiya Nyaya Samhita that comprises of the offences against the public tranquility addresses acts that promote enmity between groups or disturb communal harmony. Section 197 criminalizes imputation or asserting prejudicial to national integration, thereby reinforcing unity and the integrity of the state. Collectively, these sections, comprising from 189 to 197 of the Bharatiya Nyaya Samhita, the provisions of these sections safeguard public order by addressing both collective violence and act undermining social cohesion. The very first section, section 189 of the Bharatiya Nyaya Samhita, that talks about the unlawful assembly, that provides what constitutes an unlawful assembly and under what circumstance this unlawful assembly will be liable, any member of that unlawful assembly will be liable for the purpose of committing any offense. Section 189 of the provides unlawful assembly, that is, an assembly of 5 or more persons is designated an unlawful assembly if the common object of the person composing that assembly is number 1 to overawe by criminal force or show of criminal force the central government or any state government or parliament or the legislature of any state or any public servant in the exercise of the lawful power of such public servant. B. To resist, that is an assembly of 5 or more persons is designated an unlawful assembly if the common object is to resist the execution of any law or of any legal process. Or C. To commit any mischief or criminal trespass or other offense. Or D. By means of criminal force or show of criminal force to any person to take or obtain possession of any property or to deprive any person of the enjoyment of a right of way or of the use of water or other incorporeal right of which he is in possession or enjoyment, or to enforce any right or supposed right. Or E, that is by means of criminal force or show of criminal force, to compel any person to do what is not legally bound to do, or to omit to do what he is legally entitled to do. That is to say, that if the common object of an assembly, which compose five or more than 5%, or do any one of these five categories of the offences which are enumerated under section 189 of this Bharatiya Nyaya Samhita, then it will be said to be an unlawful assembly. Subsection 2 of section 189 provides, whoever, being aware of facts which render any assembly unlawful assembly, intentionally joins that assembly or continues in it, is said to be a member of an unlawful assembly, and such member shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Subsection 3 provides, whoever joins or continues in an unlawful assembly, knowing that such unlawful assembly has been commanded in the manner prescribed by law to disperse, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Subsection 4 of section 189 provides, whoever, being armed with any deadly weapon or with anything which used as a weapon of offense is likely to cause death, is a member of an unlawful assembly, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Subsection 5 of section 189 further provides that whoever knowingly joins or continues in any assembly of 5 or more persons likely to cause a disturbance of the public peace, after such assembly has been lawfully commanded to disperse, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Explanation appended to section 189 provides that if the assembly is an unlawful assembly within the meaning of subsection 1, the offender shall be punished under subsection 3 of section 189 of this Bharatiya Nyaya Samhita. Subsection 6 further provides, whoever hires or engages or employs or promotes or connives at the hiring, engagement, or employment of any person to join or become a member of any unlawful assembly shall be punishable as a member of such assembly, that is, as a member of such unlawful assembly, and for any offense which may be committed by any such person as a member of such unlawful assembly in pursuance of such hiring, engagement, or employment in the same manner as if he had been a member of such unlawful assembly, or himself had committed such offense. Subsection 7 of this section further provides, whoever harbors, receives, or assembles in any house or premises in his occupation or charge or under his control any person knowing that such person has been hired, engaged, or employed, or are about to be hired, engaged, or employed to join or become a member of an unlawful assembly shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Subsection 8 of section 189 further provides that whoever is engaged or hired or offers or attempts to be hired or engaged to do or assist in doing any of the acts specified in subsection 1 shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Subsection 9 of section 189 further provides that whoever, being so engaged or hired as referred in subsection 8, goes armed or engages or offers to go armed with any deadly weapon or with anything which used as a weapon of offense is likely to cause death shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. This section 189 subsection 1 defines and also provides ingredients of unlawful assembly. That is, definition and ingredient of unlawful assembly is provided under section 189 subsection 1 of the Bharatiya Nyaya Samhita. The object of section 189 and subsection 1 is to prevent to resort to criminal force by five or more to do any of the acts stated in this section. An historical background of this section that in early times mere assembly of men was considered a menace to the society and was therefore regarded unlawful. But later on, with the development of democratic societies, the assembly of men became a public necessity. Assembly of men cannot be punished if it is for a lawful purpose, because mere assembly is not punishable unless it is for an unlawful purpose. Therefore, it becomes necessary to describe those unlawful objects which make an assembly unlawful. Now, the illegality is transferred from assembly to the object of the assembly. The essence of offense under section 189 subsection 1 is the combination of several persons united for the purpose of committing a criminal offense, and consensus of purpose is itself an offense distinct from the criminal offense which these persons agree and intend to commit. This subsection 2, whoever being aware of facts which render any assembly an unlawful assembly, intentionally joins that assembly or continues in it, is said to be a member of an unlawful assembly, and as such member shall be punished with imprisonment of either description for a term which may extend to 6 months or fine or with both. Next, it provides whoever joins or continues in an unlawful assembly, knowing that such unlawful assembly has been commanded in the manner prescribed by law to disperse, shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Then of subsection 4, whoever being armed with any deadly weapon or with anything which used as a weapon of offense is likely to cause death, is a member of an unlawful assembly, shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Further, it provides whoever knowingly joins or continues in any assembly of 5 or more persons likely to cause a disturbance of the public peace after such assembly has been lawfully commanded to disperse shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. Subsection 6 elaborately provides whoever hires or engages or employs or promotes or connives at the hiring, engagement or employment of any person to join or become a member of an unlawful assembly shall be punishable as a member of such unlawful assembly, and for any offense which may be committed by any such person as a member of such unlawful assembly in pursuance of such hiring, engagement, or employment in the same manner as if he had been a member of such unlawful assembly or himself had committed such offense. Subsection 7 of section 189 elaborates that whoever harbors, receives, or assembles in any house or premises in his occupation or charge or under his control any persons, knowing that such person have been hired, engaged, or employed, or are about to be hired, engaged, or employed to join or become members of an unlawful assembly shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. Then subsection 8 of section 189 provides that whoever is engaged or hired or offers or attempts to be hired, engaged to do or assist in doing any of the acts specified in subsection 1, that is 5 categories of the offences which are enumerated under section 189 subsection 1 of the Bharatiya Nyaya Samhita, shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. Subsection 9 further elaborate that whoever being so engaged or hired as referred to in subsection 8 goes armed or engages or offers to go armed with any deadly weapon or anything which used as a weapon of offense is likely to cause death shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Then the ingredient of section 189 is, that is, an unlawful assembly is an assembly of 5 or more persons if their common object is, number 1, to overawe by criminal force the central government, the state government, or the legislature, or any public servant in the exercise of the lawful power. Second ingredient, that is to resist the execution of law or legal process. Third, to commit mischief, criminal trespass, or any other offense. Then the fourth one is by criminal force to take or obtain possession of any property, or B, to deprive any person of any incorporeal right, or C, to enforce any right or supposed right. Then the fifth ingredient is by criminal force to compel any person to do what he is not legally bound to do, or to omit what he is legally entitled to do. Then the 5 or more persons, the essential ingredient, because if there is less than 5 persons, they cannot constitute an unlawful assembly. So the requirement is that to constitute an unlawful assembly, there must be more than 4 persons, that is at least 5 or more than 5 persons. They must share the common object of others, where more than 5 are prosecuted for writing, but some of them are acquitted, and those who are convicted are less than 5 in number. The conviction is bad in law and that may be termed as illegal. Then the common object. The essence of an unlawful assembly is the common object of the persons forming assembly. The object must be common to all those persons who constitute the assembly. That is, they should all be aware of it and must concur in it. The object must be one of those set out in this section. That is, mere presence in an assembly does not make a person member of an unlawful assembly unless it is shown that he had done something or omitted to do something which would make him a member of the unlawful assembly, or unless being aware of the facts that an assembly is unlawful one intentionally joins that assembly or continues to be its member. An assembly of 5 or more persons cannot be called an unlawful assembly if its object is to defend property by the use of force within the limits prescribed by the law. that is, the right of private defense of property. The Supreme Court in Masalati versus State of Uttar Pradesh observed in fact, Section 149 IPC, that is Section 190 of the Bharatiya Nyaya Samhita, makes it clear that if an offence is committed by any member of an unlawful assembly in furtherance of a common object of that assembly, or such as the members of that assembly knew to be likely to be committed in furtherance of that object, every person who, at the time of committing of the offence, is a member of the same assembly is guilty of that offence. And that emphatically brings out the principle that the punishment prescribed under Section 149 Indian Penal Code is in a sense vicarious and does not always proceed on the basis that the offence has been actually committed by every member of unlawful assembly. From what has been stated above, it is evident that Section 189 subsection 1, Section 191 subsection 1 and Section 191 subsection 3 create distinct offences, whereas Section 190 only creates vicarious liability. However, Section 191 subsection 1, Section 191 subsection 3 and 190 contain certain legislative declaration based on doctrine of vicarious liability. The doctrine is sparingly applied in criminal law. It applies for the offence of unlawful assembly as defined under Section 189 subsection 1 and made punishable under Section 189 subsection 2 of the Bharatiya Nyaya Samhita. Class A, that the first illegal object is to overawe by criminal force the government, the legislature, or the public servant, etc. A person is said to overawe another when he restrains him by awe, fear, or superior influence. Overawing merely by superior influence is not criminal, nor is overawing by fear illegal, unless it is attended by show of criminal force. But where a person is terrified into doing what he had otherwise no mind to do, and refraining from doing what he had otherwise a mind to do, he is said to be overawed, and where that fear is brought on by the show of force, he is said to be overawed by show of criminal force. In order that this section may apply, it is necessary that the assembly should have had the common object to overawe, and it is not enough that the assembly did have the effect of overawing. Clause B provides that under this clause, the act resisted must be a legal act, where a number of persons resisted an attempt to search a house which was being made by officers who did not have the power and authority to do so. This resistance was held to be legal, and those involved in resisting were not guilty of the offence under this section. The execution of any law means the carrying out of the provision of law or the enforcement of any act warranted by law. Process means a measure and a legal process, and a legal process means a measure in accordance with law. Resistance to some law or legal process connotes some overt act, and mere word when there is no intention of carrying them into effect are not sufficient to prove an intention to resist. The Supreme Court in the state of Uttar Pradesh versus Niyamat and others held that assembling together of persons with the common object of rescuing an innocent person from unlawful police detention could not be held to be constituting an unlawful assembly under section 141 of the Indian Penal Code, that is section 189 subsection 1 of the Bharatiya Nyaya Samhita 2023. Then clause C, although only two offences are specifically enumerated in this clause, but the word or other offences used in this class means that it is intended to include all offences. But if that was the intention of the legislature, one fails to understand as to why only mischief and criminal trespass were specifically mentioned here in this clause. Clause D provides that the aims at punishing the act because of their injurious consequences, which it is likely to cause to public peace. This clause does not take away the right of private defense of property. The rule that no person is entitled to vindicate his right to possession of any property by resort to criminal force appears to be in conflict with the law relating to private defense of property. But the courts do recognize the right of private defense because if the use of force is justifiable under one section, it cannot be held unjustifiable under this or any other section of the Bharatiya Nyaya Samhita or any other law for that purpose. The expression right or supposed rights makes a division into number one, rights in actual enjoyment when interfered with, and number two, rights claimed through though not in actual enjoyment with interfered with. Where a person is in undoubted possession of his land and it is attacked by where a person is in undoubted possession of his land and it is attacked, he has every right to defend within the limits of the law of private defense under the Sanhita. Acts done in defense of property in such cases cannot be said to be done to enforce any right. But of course, in cases of doubtful claims, if either party used force, that would amount to enforcing a right, and in that case, there would be no right of private defense. In Dambabu case, a license was obtained for taking out a procession, but the procession violated the conditions of license by not observing the prescribed route and by crossing the limit up to which the procession was permitted to proceed. The police and the magistrate directed them not to do so, but a group of processionists made a determined bid to break through the police cordon. It was held that the group constituted an unlawful assembly. In Ray Abdul Sattar case, a procession was moving on the permitted route accompanied by music and was interrupted and attacked by brickbats, stones, and empty bottles collected inside a mosque. All those persons indulging in this activity were held to be members of an unlawful assembly, as their common object was to deprive the processionists of their right of way to which they were legally entitled. Then, after the fifth clause, that is clause E, in order to bring a case under this section, it would not be enough to prove show of criminal force or use of criminal force to take possession of property, unless the use of force was accompanied by some criminal intent. For instance, if A sees B committing theft, A is entitled to arrest B under section 40 of the Bharatiya Nagrik Suraksha Samhita 2023. If some other persons intervene to secure release of the thief from A, their act falls within the ambit of clause E of this section and they will be guilty of the offence under section 191 subsection 2 of the Bharatiya Nyaya Samhita 2023. Explanation provides with the help of a case law that is in Moti Das versus State of Bihar. In this case, the Supreme Court noted that with approval that an assembly which was lawful in its inception may turn out into an unlawful assembly by the subsequent acts of its member and without previous consent among its members, provided others forming the assembly have also acquiesced in such unlawful act. Illegal acts of one or more members not acquiesced in by others do not make the assembly unlawful. Where some persons associate themselves with the mob with innocent motives, but they take part in the proceeding even when the assembly has become unlawful, they will be liable as being members of an unlawful assembly. Certain persons assembled to prevent a procession by force from passing over a certain street. They neglected the orders of the police when asked to disperse. Therefore, they were held guilty of being members of an unlawful assembly. Some of the cases must be discussed just in order to understand in elaborate way the very provision which is provided under section 189 of this Bharatiya Nyaya Samhita. In Banwari Wallal versus State of Rajasthan, the accused, 6 in number, came armed with deadly weapons and surrounded Shiv Prasad and Man Singh. One of them shouted to exterminate the enemy while others were beating them. It was held that none of the 6 accused persons who happened to be present at the place of the occurrence and participated in assault could be said to be there for innocent purpose. The nature of the weapon which they were holding from the very beginning and the fact that all of them had come together from a pretty long distance at a place which was neither in front of their house nor in front of their land, as also the fact that all of them emerged at a time and participated in the assault and went away together after causing numerous injuries, suggested that all those accused constituted themselves into an unlawful assembly. The common object of the persons comprising that assembly was obviously to commit criminal force, namely murder. The Supreme Court in Shivji Singh versus State of Bihar held that an assembly which is lawful at its commencement can develop during the course of incident at its spot to become unlawful, as provided in explanation appended to section 141 Indian Penal Code, that is section 189 subsection 1 of the Bharatiya Nyaya Samhita. It is not necessary to render an assembly unlawful when it comes into existence at the outset. The time of forming an unlawful intent is not material. An assembly which at its commencement or even for some time thereafter is lawful may subsequently become unlawful. In this case, a quarrel is started between two persons on the holy festival day on March 9, 1993. The appellant called his 3 sons and came armed with gun and stick and started throwing stone and brick pieces from the top of the roof and opened fire, causing grievous injuries to 3 persons and one Megnath was shot dead. The injured were carried to hospital on tractor and remained under treatment for about a week. The accused persons were convicted for perpetrating the crime by common intention and sentenced under section 302 read with section 147 of Indian Penal Code, that is section 103 subsection 1 read with section 191 subsection 2 of the Bharatiya Nyaya Samhita. Now, subsection 2 of section 189 simply provides that being a member of unlawful assembly. Section 189 subsection 2 makes it clear that a person remains in an unlawful assembly after he became aware that the assembly was unlawful. He shall be deemed to be a member of an unlawful assembly and shall be liable as such. In order to attract this section, one should either intentionally join knowing that the assembly is unlawful or continue to be a member after being aware of the fact that an assembly, though not unlawful at its inception, has subsequently turned out to be so. Here, continuous means physical presence with the knowledge of unlawful character of the assembly. Then, joining or continuing in unlawful assembly, knowing it has been commanded to disperse, that is section 189 subsection 3. Section 189 subsection 3 aims at punishing the disobedience of any lawful order promulgated by a public servant. The order must relate to dispersing an unlawful assembly. In the case of Jagmohan versus State of Odisha, a public meeting was going on in order to discuss the arrest of some of the railway employees who were on strike. In the meeting, two of the speakers incited the police to resolve or revolt against the government, while the accused, that is one of the speakers, merely appealed to the public to support the strikers. The High Court of Odisha held that the accused had no common object to incite the police against the government and the assembly as unlawful. Therefore, if the persons attending that meeting did not disperse even after being commanded by the police to do so, they could not be held guilty of the offense under section 145 Indian Penal Code, that is section 189 subsection 3 of the Bharatiya Nyaya Samhita. It may, however, be stated that though a charge under section 145 Indian Penal Code could not succeed in this case, but a charge under section 151 Indian Penal Code, that is section 189 subsection 5 of the Bharatiya Nyaya Samhita, could have definitely survived in view of the fact that the assembly was unlawful. Its member could be presented under section 189. Its member could be presented under section 188 of the Indian Penal Code, that is section 223 of the Bharatiya Nyaya Samhita, as the order for dispersal has been lawfully given in the bona fide exercise of the police powers under section 129 subsection 1 of Criminal Procedure Code, that is section 148 subsection 1 of the Bharatiya Nagrik Suraksha Samhita 2023 for the prevention of breach of peace. Then after the meaning of joining unlawful assembly armed with deadly weapon, that is section 189 subsection 4 of the Bharatiya Nyaya Samhita. The offense under this section 189 subsection 4 is an aggravated form of the offense under section 189 subsection 2. Greater punishment is prescribed under this subsection because the risk to public tranquility is aggravated by the intention of using force evinced by carrying arms, where the accused is armed with anything which, if used as a weapon of offense, is likely to cause death, he shall be liable under section 189 subsection 4 of the Bharatiya Nyaya Samhita. Then after knowingly joining or continuing in assembly of 5 or more persons after it has been commanded to disperse, that is provided under section 189 subsection 5. For the application of Section 189, subsection 5, the assembly of five or more persons need not be an unlawful assembly, but if such assembly is likely to cause a disturbance of the public peace, then joining or continuing in such assembly after it has been commanded to disperse is punishable. However, such joining or continuing must be with the knowledge that it is likely to cause a disturbance of the public peace and that it has also been commanded to disperse. In order to prosecute the accused for an offense under Section 189, subsection 5, the prosecution must prove number one, that there was a lawful assembly of five or more persons, that such assembly was likely to cause disturbance of public peace. In order to prosecute the accused for an offense under Section 189, subsection 5, the prosecution must prove that there was a lawful assembly of five or more persons, that such assembly was likely to cause disturbance of public peace, that such assembly was commanded to disperse, that such command was lawful, that even after such command, the accused joined or continued in the assembly, and the sixth one, that the accused did not knowingly or deliberately join that very thing. The Supreme Court in Neelkantha versus State of Andhra Pradesh observed that where the police officers merely warn the two rival groups not to commit breach of peace, it cannot be said that the group, that is assembly, had been commanded to disperse, and therefore the provision of Section 151 Indian Penal Code, that is Section 189 subsection 5 of the Bharatiya Nyaya Sanhita, would not be attracted to prosecute the members of that group. The accused were therefore acquitted by the court. Next is hiring or conniving at hiring of persons to join unlawful assembly. That is Section 189 subsection 6. Ingredient of Section 189 subsection 6 are the following are the ingredient that has to be established for this offense. Number one, the accused must have done one of the following acts. A. He hired or engaged or employed a person to join the unlawful assembly. Or B. He promoted or connived at the hiring, engagement, or employment of such person to join or become a member of the unlawful assembly. 2. The person hired must have committed an offense in pursuance of such hiring, engagement, or employment. Then Section 189 subsection 6 is intended to punish the persons who are neither abettors nor participants but who nevertheless assist in the bringing an unlawful assembly into existence. The hirer will be punishable for any offense committed as if he were a member of the unlawful assembly and as if he had committed the offense. Then is harboring persons hired for an unlawful assembly, that is Section 189 subsection 7. Section 189 subsection 6 makes the hiring a person to join unlawful assembly punishable. Section 189 subsection 7 deals with the harboring, receiving, or assembling of persons hired or likely to be hired for an unlawful assembly. Knowledge on the part of harborer that person harbored have been hired or are about to be hired to join unlawful assembly is essential. Then, after being hired to take part in an unlawful assembly or to go armed, that is Section 189, subsection 8 and subsection 9. Section 189, subsection 8 makes it punishable to hire oneself out to assist in an unlawful assembly or writing. Section 189, subsection 8 and Section 189, subsection 9 is separable according to the weapon possessed by the hired person. If a hired person is armed with deadly weapon, he deserved greater punishment.